Okay, so an introduction. My name's Kevin Sadler and I'm chairing this event. I'm here because I'm both the trustee of the Centre for Justice Innovation and I have a keen and long-standing interest in the issues surrounding fines. I started working in the justice system nearly 25 years ago, and one of the first things I was asked to sort out was fine enforcement performance. Then, and arguably now too, it was rather the Cinderella of the justice system, and whilst I made some progress at the time, I'm sad to say that when I bowed out as chief executive of HMCTS a couple of years ago, there was still a lot more to improve. The centre itself is a not-for-profit organisation that seeks to build a justice system which every citizen believes is fair and effective. We deliver a range of work to deliver that vision. We provide hands-on support to practitioners. We conduct research into how things work right now and how they could work better in the future. And we promote evidence-based and innovative justice policy reforms. So for the past 3 years, the Centre has been conducting an investigation into the criminal court fine to understand more about what is often an overlooked part of the system, but is by far the most common sentencing outcome. And phase one of this project was published last year. This identified a number of issues with the way the system functions and the impact this has on people on low income in our courts. And today marks the publication of 2 follow-on reports which set out the solutions to these issues and make our courts fine system fairer, more proportionate and more effective. We'll hear first from the report authors who are going to present an overview of the project. So that's Lucy Slade, Policy Officer at the Centre for Justice Innovation, and Carmen Robin de Cruz, a Senior Research Officer at the Centre for Justice Innovation. And then I'm delighted we've got a really excellent panel with whom we can discuss the findings. We've got Jane Smith, a magistrate who sits in Central and North London, who's chair of the Magistrates Association Adult Court Committee. Penny Gibbs, the Director of Transform Justice, a charity that seeks to create a better justice system in the UK, one that's fairer, more open and more compassionate. And Christian Waters, a justice campaigner who, after being prosecuted by Northern Trains over a dispute about a broken ticket machine in 2023, was able to successfully challenge the legality of the use of the single justice procedure. And that ultimately led to the Chief Magistrate ruling that 60,000 similar cases should be quashed. We're going to hear from each speaker in turn and then we'll open the floor up for questions. As I said, please feel free to pop any questions that arise in the Q&A function, which should appear as a tab at the top. I'm now going to hand over to Lucy and Carmen, who are going to speak about the reports. Over to you.
Thanks, Kevin. So at the Centre for Justice Innovation, we started this project off about 3 years ago, knowing that the court fine is by far the most common sentence, makes up the outcome of 75% of cases in England and Wales. And we also knew that nearly half of these fines go unpaid within 12 months of sentencing. But that was about it. And with the support of the Aberdeen Group Charitable Trust, formerly the ABRDN Financial Fairness Trust, we've been able to build an evidence base to understand what's happening behind these statistics and expose a bit of a quieter injustice that's been happening every day in our courts, but also importantly, to provide some solutions. Can I get the next slide, please?
Sorry, Lucy, give me a sec.
Problem. I can keep going, Carmen, if while you get the slides up. Okay, so I'll just let everyone know that. So the first phase of the project we published last summer, and we found that while fines are used for offences deemed the least serious, the impact on people on low incomes was really anything but. Our analysis of citizens' advice data found that people with fine debts are twice as likely to be in social housing and twice as likely to be unemployed than any other client group, which are clear indicators of financial vulnerability. Now, the sentencing guidelines we found said that a fine should have an equal impact, but interviews revealed all sorts of experiences. It was a real spectrum, from an inconvenience to a manageable hardship. And for those on the lowest income, the consequences were disproportionately severe. And these are people who are already struggling to meet their basic living costs, and paying the fine in some cases meant going without heating, food, or even rent. So I'm going to hand over to Carmen, who's going to talk us through her section of the report, because since this research, we've been digging deeper into how things are currently working, and outline some practical options for reform, which we've developed with experts from the world of debt advice, court operations, and people who have experienced the system, which we're really excited to be able to share with you today. So yeah, I'm just going to pass over to Carmen to tell us more.
Thanks, Lucy. So yeah, our first report called for a fairer and more effective system built on a consistent framework for ordering, setting and reviewing fines that's responsive to people's financial circumstances, centering considerations of affordability and proportionality. So our job in this report was to consider practical options for that reform once we had kind of mapped current practice in greater detail. So to do that, we conducted court observations, we did court practitioner interviews and a solution-focused practitioner workshop. We conducted some service user focus groups with the help of user voice and also public opinion and polling. And we also drew on the really rich data we got from phase 1, in particular the service user interviews and magistrates workshops. So the notion of equal impact and no one being asked to pay more than they can afford is really central to the system. It relies on courts having an accurate picture of defendants' financial circumstances together with a functional income adjustable framework for responding to those circumstances. But our research identified issues around both of those. So we found collection of financial information to be really inadequate, or often inadequate. Some service users even reported that they'd never been asked to provide any details about their circumstances. And the MC100 means form was the main mode of collecting financial information. But again, we found it to be outdated, to be poorly used and overly complex. It's almost never used by the most financially vulnerable, and some courts have done away with it altogether. And you can see from these quotes that service users' frustration with the form was really clear. So, for example, the whole stress and everything you're going through in that moment, to then be handed this form and try to focus on your outgoings is a bit difficult. Why would they actually ask you for all this, though, if you're homeless and you're not working? And practitioners were critical about the form too. So, for example, they were really worried that the form was being used in single justice procedure cases. They just didn't think it was being completed. So they, SJP defendants, are sent their means forms with their court papers, but of course the vast majority don't ever respond to those, so we don't actually get their means information at all. And participants called for the form to be replaced with one that's fit for purpose, and they also wanted to see more effective use of technology. So, for example, we have a service user asking, how about they just digitize the whole thing? And hand in hand with that technology use was the idea of including real-time verification of income, facilitated by DWP and HMRC data connections. And it was thought that this would do 3 things. So first, reduce the burden on people who might struggle to provide that information themselves. Next, to increase revenue from high earners by not allowing them to so readily rely on the default income figure. And finally, to support decision-making in cases where there's no input from the defendant as to their means. So next, our research found that as well as suffering from the effects of poor financial information capture, the processes around setting fine and financial order amounts lacks transparency. So service users often saw the process as arbitrary or detached from means. So, for example, one service user told us they never adapt the fines to people's income or outgoings. I think they've just got set markers for fines. It doesn't matter if you're on the dole or you're a millionaire. And practitioners also found the process to be quite uncertain themselves. 99% of the time, we just use some rule or fairy stories. And even where the fine was perceived as being set appropriately, tailored to someone's financial circumstances, financial orders on top, things like prosecution costs, compensation orders, surcharge, were often viewed by service users as hidden costs, and they could tip the overall amount to be paid into something that was really unachievable and impossible to pay overall. So, for example, a service user told us, I thought it was quite extreme because the actual fine itself was only £60, but then with all the interest on top and the court fees and all that, that's what it adds up to. It's quite a lot of money if you don't have it. And practitioners highlighted the surcharge as being particularly problematic. So they said there was kind of almost no discretion, no room for discretion to take account for personal financial circumstances. They wanted this to be addressed. If there is a way of having a sliding scale of that surcharge, depending on people's means, then I think that would be a little bit fairer. So since the 1st of September 2025, the sentencing guidelines have included, it is important that a fine is not imposed on an offender without sufficient means to pay. And while that's obviously very welcome, more clarity is needed on what the courts can actually do instead. And the most pressing challenge raised through our research was the need for alternatives to fines for the poorest. So the sentencing guidelines make clear that a fine shouldn't force someone below a reasonable subsistence level, but our research found that people clearly being fined contrary to this. So, for example, from a service user, they've nobbled me with the £750 fine, which is crippling, and so far I haven't paid a penny of it. And with no fixed abode, I told them in court, and they just went, right, you've been fined, off you go. So fines in these circumstances not only have a disproportionate financial impact, but they also have little hope of being paid. And magistrates also expressed extreme frustration around this and a sense of powerlessness when it came to sentencing someone whose offence didn't reach the level the threshold of a community sentence, but they knew that they weren't going to really struggle to pay that fine. It's not something that we'd want to do, but we lack any alternatives, and I think that's a problem for the courts. So this is out fully in the report, but participants discussed various alternatives. So we talked about conditional discharge, out-of-court resolutions, unpaid work, deferred sentencing, and conditional discharge with a referral or signposting to a relevant service, so maybe around debt or housing advice, was the option that was most widely considered as appropriate and to be a really problem-solving approach as well. So in terms of managing existing fines and financial orders, we did see some really good practice, but on the whole, we found that the system could be inflexible and ineffective, especially when it came to responding to changed financial circumstances, which might make a fine no longer affordable, or to responding to people who had fallen behind on their payments. And we found many service users weren't aware that the option of reviewing existing fines even existed. I didn't even know that was available or possible to do. And where someone did actually reach out to the fines office, they didn't always respond appropriately. So that could lead to unnecessary escalation, or it could lead to a person being left below the level of subsistence by having to pay that fine as it stood. And practitioners also highlighted this as a practice area that's really in need of improvement. It seemed clear to me that the enforcement system needed to improve its engagement with people who are struggling to pay. And again, we saw some really positive practice in enforcement court. So magistrate and legal advisor are working really closely together to remit fines kind of in whole or in part as appropriate. But again, there was a really palpable sense, real frustration that maybe enforcement court was being used or relied too heavily on as a backstop. So practitioners told us that they were frustrated at wasting court time doing what fines officers ought to be doing, or remitting fines that people are clearly unable to afford from the outset. There's a question about whether or not actually, if they do keep coming back through the system, actually is the fine working? And again, that goes back to having the right financial information at the outset, and also having those alternatives to fines for the poorest in place. So participants called for a more problem-solving approach. They wanted to see people who are struggling to pay or who fall behind on payments offered opportunities to engage, to explain their difficulties, and to explore alternative arrangements. And they also wanted to see a transparent, user-friendly online system for paying and managing their fines and financial orders. So our recommendations, we go into great detail in the report, but I'm just going to do a little whistle-stop tour now. So 6 key changes that we're hoping are going to lead to a fairer and more effective system. The first is to reform sentencing guidelines to be more comprehensive and consistent. So the idea is that this would provide a framework for determining the maximum total amount a person can reasonably order to pay across all their fines and financial orders, based on their disposable income, having taken into account essential outgoings. The guidelines should also allow appropriate room for judicial discretion, in particular having the option to waive the surcharge where it's not affordable. Next, develop a new and more streamlined system for collecting information. So this is about a new MC 100, and that would be more streamlined and kind of cut to the chase and identify how much income is going on essential outgoings and how much remains disposable. And it should be available, accessible online and in paper, and available in advance of the hearing as well as on the day. And we also recommend in the report that HMCTS should partner with community advice or other local third sector services that can help provide defendants with support in completing that form within the court building. Finally, improve courts' access to income and fine data to assist improved decision making. So this is about courts being able to verify people's income kind of live, and that's in both physical courts and SJB cases. And again, that would be supported through data connections with HMCTS data connections with HMRC and DWP. And practitioners are also really clear, magistrates really wanted to have better access to existing fines on account to inform decision making. Next, ensure that the courts can identify and provide alternatives to people unable to pay. So one way of doing this would be having a standard checklist in court to identify those people who can't afford to pay any amount, and then the sentencing guidelines really clearly outlining alternatives in such cases, one of which might be a conditional discharge coupled with a referral, signposting to advice and support services. Next, create a transparent, user-friendly and problem-solving system for managing fines and financial orders. So the idea of HMCTS setting up kind of a one-stop online system where people can disclose their financial information, pay, check their balance, notify courts about a change in financial circumstances or that they're struggling to pay, and also embedding that problem-solving approach. So giving people the opportunity to engage, to explain their situation and explore alternative arrangements where that's necessary. And finally, we recommend empowering specially trained fines officers to review fine and repayment levels when people's circumstances change or when new information that wasn't available at the time comes to light. Thanks.
Great. Okay, so something that came through very clearly from the research that we conducted last year was how many of the cases that are making its way to court and resulting in a fine that to us really could have been dealt with at a much earlier point. So my report sets out a roadmap towards ensuring that only the cases that really need to be in court reach that stage. Have the next slide, please. That's coming. So achieving this can be done one simple way through within the current powers of the justice system that we already have, out of court resolutions and diversion. They're schemes that have been used in parts of the country for many years, and they've proven that they can effectively resolve cases without processing the individual through the courts. The approach has got a really strong evidence base. It shows we minimise contact with the system and provide an opportunity for people to engage in a programme of support or victim engagement. This can lead to a better outcome and reduce the chance that they'll go on to commit another offence. And while out-of-court resolutions have become routine in some parts of police practice in some areas across the country, nationally, we've seen their use fall quite significantly. In 2010, they made up 26% of all outcomes, and by 2024, this was down to 14%. And how these schemes operate also really varies across the country. So we think that if we restore the proportion of cases that are resolved out of court and bring greater national consistency, these are two ways the government can reduce the burden on the courts to impose and enforce fines that aren't getting paid. And this was supported by the Leveson Review of Criminal Courts, which called for more out-of-court resolutions to free up the courts to deal with more serious and complex cases. Can I have the next slide? Thank you. So something else that we kept hearing throughout the interviews were cases that had ended up in a court fine, but for really minor infractions, things like dropping a cigarette. And so I was able to take some time to investigate this further, find out what was going on. And we believe that these cases most likely started off as a different kind of fine, a fixed penalty notice fine, which are either used by the police and local authorities in response to things like speeding, not paying your MOT, littering, not picking up dog poo. And a fixed one-off fine in these cases seems like a fairly reasonable response. But if the person doesn't pay, they can be prosecuted and end up with a court fine and a criminal record. And through a number of freedom of information requests that we made to local authorities in a range of areas across the country, we found that local authorities are making heavy use of this power to prosecute people. We found out that Birmingham City Council, for example, prosecuted nearly 2,000 people in a 12-month period. And this escalation felt wildly disproportionate to the types of behaviours that we're talking about. And I included the photo on the right because I think it makes that point quite well. I took that this weekend while I was in Brick Lane in London. And so when we look at the data, FPNs have a high non-payment rate. Nationally, 50% of FPNs result in prosecution at court. So to us, this seems like we have a system that's pushing uncollected debts from one state actor to another, as we know that 50% of court fines are going unpaid as well, 12 months on. And there's a real data gap here. There's not any data about who are the people who aren't paying their fixed penalty notice fines and why. But we do know there's a lot of poverty amongst people in contact with the justice system. We know that people on low income struggle to pay court fines. And there's a lot of evidence around government debts that have become the most problematic debts for people in financial difficulty to pay back. And our research also found the enforcement system for FPNs, it doesn't try and identify if inability to pay is a factor and opts straight for prosecution. And a big issue is that most of these cases will be processed through the single justice procedure, which involves a single magistrate dealing with minor offences without a public hearing at court. Our awareness has been growing thanks to the work of Penelope and Christian, who we have on our panel, about the issues with the SJP convicting people without their knowledge and not giving them the opportunity to present mitigating circumstances such as poverty or other vulnerabilities. And the harm that can be caused as a result of this enforcement system when people can't pay is demonstrated by the experience of one man that we spoke to during our interviews. We call him Tom in the report. He had received a £60 fixed penalty notice fine for littering after dropping a cigarette. He couldn't pay the fine because he was already in a lot of debt and his universal credit wasn't enough to live on. He was taken to court. He received a fine of £500 and a criminal record. And the court told him that paying his fine should be a priority over his other debts or he risked going to prison. So he agreed to £5 deductions to be made to his benefits every week, which meant that some days he told us he was going without food and he was constantly worried about not being able to pay his bills. So as a result of all of this, we are calling on the government to review the causes of fixed penalty fine non-payment and bring the sanction system in line with good debt enforcement practices. Can I have the next slide, Carmen? Thanks. So our research also found that fine cases in magistrates' courts being inflated by another practice, train operating companies using the court system to pursue criminal proceedings for fare evasion. Now, of course, we want everyone to pay for their train ticket and companies should be able to respond. But a review was recently conducted by the Office for Road and Rail, and it described enforcement practices as a complete Wild West, with every company taking a different approach. And the report outlines how train companies are allowed to bypass fairer and more proportionate sanctions, such as penalty fares, and opt outright for criminal prosecutions, even for minor breaches of terms and conditions, like travelling on off-peak trains. And the OOR also found that train companies are incentivised to be using the criminal courts to do this because it's quicker and it's easier to get money from people, get compensation, than through the civil courts. But the consequences are really severe for the people on the sharp end of these prosecutions. It's a criminal record and it's a large court fine. And this system that's geared towards imposing the largest possible financial sanction, it really fails to take into account the fact that not having the money for the ticket might play a factor in the first place. But it also means that the state and the public are bearing the cost of enforcing payment, which is essentially owed to private companies. And perhaps most damning, the ORR couldn't identify any evidence to suggest that criminal prosecution reduces fare evasion other than other alternative enforcement measures. So this has led us to conclude that it would be a better system if rail fare evasion is moved into the civil justice system, and we have a fairer system where they use warnings, no further action for genuine mistakes, terms and condition breaches, using penalty fare notices for more serious cases of evasion, and then if these are not paid, pursuing them through the county court judgments in the civil courts. Okay, next slide. Carmen, if you can. Thank you. So lastly, there are 3 categories of offences that often result in a fine, despite being heavily associated with poverty, which to us, we just don't believe there should be any criminal justice intervention at all. So these are truancy, offences criminalising activity related to sex work, and behaviours associated with homelessness. And this section of the report really stands on the shoulders of all the experts and campaigners who for many years in these areas have been showing that punitive responses don't deter, they don't help people, but it pushes them away from support. So therefore, we're calling for the repeal of these offences and investing in welfare-led interventions where they're necessary. Last slide, Carmen. So to sum up, research suggests that the current system of criminal court fines is delivering both poor outcomes for the individual, but also the state. And the reform we set out, we think it can deliver on fairness, but also efficiency. We've done some analysis of how many cases these reforms could potentially take out of the court system. And we believe it could be 60,000 cases a year off the court caseload. And polling that we conducted found that this is something the public can get behind. 73% agreed that an alternative punishment should be used when someone cannot afford to pay a fine. Okay, well, thank you very much for listening. That's all for me for now.
Okay, thanks, Lucy and Carmen. That was really helpful. I'm now going to hand over to the panel for reflections, and I'm going to start with Jane Smith from the Magistrates Association. Over to you, Jane.
Thank you very much, Kevin. Firstly, I think I have to say that to the centre and to Carmen and Lucy, I think there's a very substantial bit of research and policy work really thoroughly done. So well done. And of course, it's hard to disagree with much of what you've found. That many people on low incomes struggle to pay court fines. The Magistrates Association has made that point in its evidence to the sentencing review, and we see it every day in court. We do need some realistic alternatives for low-level offences, and I'll come back to that point of view. From the sentencer's point of view, and the report recognises this, there is a limited amount of things that we can do to sentence the offenders who come before us for minor offences. We have sentencing guidelines, and there's a clear hierarchy of sentencing in the courts, which goes from fines at the bottom through community orders to custody. Yet, as you say, out-of-court disposals can be much more flexible, which is why one of your recommendations suggests the possibility of courts referring back for consideration of an out-of-court disposal. We can do that, but prosecutors can and do refuse. I think out-of-court disposals also sort of ride a coach and horses through the sentencing hierarchy. So take, for example, the case of a woman with a minor offence who's diverted from the courts. She can be referred to a women's centre and receive exactly the same sort of support and programme that a woman who comes to court for a more serious offence and gets a community order. But that minor offence she commits doesn't warrant a community order, and say she or her sister comes to court for the same offence, then all the courts can do is impose a fine. So one woman gets a criminal record and accrued punishment, which might or might not put her in financial difficulties, and the other gets a real offer of help and a lesser criminal record. So what can we do? We can waive prosecution costs. That's one of the costs that gets imposed. We can't waive the surcharge officially. We can deem fines served by time spent in custody, either in prison in police cells overnight or held in the courthouse. And we can give priority to compensation and not impose a fine or a surcharge. We can impose a conditional discharge if that's an otherwise reasonable sentence. I think your report mentions some pilots that were done over 10 years ago of unpaid work as an alternative to fines. But that's not necessarily a straightforward answer. Some see that as up-tariffing, and many of the people who have difficulty paying fines will also struggle with unpaid work. One thing people can do is come back to court and ask for their fines to be varied, but I'm not clear how many do, and I think that's one of the points you made, the data aren't there, or how many know that they can do that. I think there's a lesson in your work that as magistrates, we probably need to explain better how the fine has been calculated. I think we would say that we do take account of means, but may not spell it out as often as we should. And our mechanisms for finding out about means are crude. So looking at recommendations, I think there are several practical suggestions for improvements that Carmen outlined, like improving the information on means available to the court through linking with DWP and HMRC databases, though that would have to be simple and fast. Empowering fines officers to make adjustments or refer back to court, and providing people an online system to track their fines, make amendments to their circumstances and seek reviews. But I'd like to pick up a couple of points from the policy suggestions. The recommendation to increase the use of out-of-court resolutions. Sort of yes, but the current system is a mess. There are variations around the country. Different police forces do different things. Some forces give out-of-court disposals to repeat offenders, and some for serious offences like knife crimes. Also, they're completely untransparent. We know little about the quality of the assessments made, the programmes offered, and the courts don't know about them. So I think the Magistrates Association would like to see some of the options available under out-of-court disposals available as standalone sentences as alternatives to fines, without them being tarnished with an up-tariffing label. It's interesting that the Gork sentencing review suggested that there should be alternative standalone options, and many of them have found their way into the sentencing bill, but as community order requirements. I think I stand to be corrected that the sentencing bill largely ignores fines. It's bothered about people in prison, really. And then finally, I'd just like to comment on two of the other recommendations: to reform the fixed penalty notice system and enforce rail fare evasion in the civil courts rather than the criminal courts. Yes, those are both sensible suggestions, but I'd like to touch on the point that Lucy raised about lack of engagement. One problem with both those things is that people don't engage with them, and if they don't, they end up both in court and more expensive. And that's, whether it's a single justice process or the preceding procedure where they were in court, we still dealt with loads of cases where people just hadn't engaged. And if there's no plea and no information, it'll be proved in absence and they'll get the standard fine because there's no other information. The Magistrates Association has urged improvement in the forms and the information that people get, and also using text and emails to communicate might help, though the systems need to have that information. But I think lack of engagement is a real problem, and I don't quite know how you get around that. And if that remains the case, you simply shift the problem of rail fares from one court system to another, from prime to civil, and the outcomes for the offender may or may not be better. But nevertheless, they're both sensible suggestions, even though I think fines as a punishment remains a difficult problem. Thank you.
Hey, thank you, Jane. That was really, really helpful. I'm going to hand over to Penny Gibbs now from Transform Justice for her perspective.
Hi, thanks very much. And I welcome these two very important reports. And I will plug one of my own, which is that Transform Justice did a report solely on the single justice procedure entitled Industrial Scale Prosecution. So that talks about the fines and other things. And I would just say as well that I totally agree that the fine system, what is imposed on whom for how long, it is not working very well. We have a Court Watch project whereby people are observing, have been observing the London Magistrates' Courts. And I was reading the other day about a guy who'd been illegally trading on Lambeth Bridge. He was selling hot dogs. He was given a fine of £6,720, and it was agreed that he would pay that off at £50 a month. So that was going to take him 11 years to pay off, which just seems a kind of crazy system. So definitely a Cinderella which needs looking at. I'll look at two of the options in the policy paper, just from the point of view of support, really. So the option of greater use of out-of-court resolutions, I'm wholly in favour and don't have the reservations that Jane had. Transparency could be a little better, but the main people that the system needs to be transparent with are the victims concerned in these cases. And we did some research on victims' attitudes and experiences of having their crime, as it were, dealt with out of court. And in fact, you know, victims were incredibly supportive. They weren't very keen to go to court or have the case go to court. They were very supportive of it being dealt with out of court, and their experiences were entirely dependent on the police practice, not kind of what was offered. So it was about whether it was fast, whether the information was available, and so on. So, and it actually, if somebody goes to court and gets a fine, the victim's experience, they'll be lucky if they're told that, to be honest, or they get that information reliably. Whereas at least with the out-of-court resolution, if practice is followed, they have an interaction with a police officer and they feel that they're consulted about what might happen. So everything can be improved, but from a rehabilitative point of view and a reoffending point of view, all the data on out of court is better than the court fine. So the Ministry of Justice does these statistics on reoffending rates, which are based on thousands of cases. And the reoffending rate for the caution is way better and has been for years and years than any court sanction, including the court fine. It has to be said that the reoffending rate for the court fine is better than the community order, but it's still not as good as out of court. So we would wholeheartedly support out of court. Obviously, one of the issues is that once it's gone to court, the sort of conveyor belt has really started. And that is often because the person, the defendant, didn't admit responsibility in custody, in police custody. So the improvement really needs to happen in police custody, though there are kind of mechanisms that could be used to try and push back cases from court, which are as it were, at the door of the court, which they are occasionally reviewed, but it's not that often. And I think Transform Justice would say that every single case which now gets a fine could theoretically be dealt with out of court instead. Obviously, you need, in our current system, for that person to accept responsibility, but technically, according to the offence, we don't see why not. In terms of other recommendations, so that would divert a lot of cases, which get a fine now from court, which would also be beneficial to the magistrates' court backlog, which at the moment is very, very high. And they are, as it were, with conditional absolute discharge, the sort of bottom level of the court. In terms of other cases which could be diverted, I'm afraid the single justice procedure cases can't be diverted the same way. It's a different system altogether. So for diversion into out-of-court resolutions, which are cautions and community resolutions, it has to be a police or CPS prosecuted crime. And that can be diverted and a kind of rehabilitative option used instead. But single justice procedure crimes are different. Some of them are prosecuted by the police, but they're a category of crime for which there is no out-of-court resolution available. It is not the alternative. So it really is either prosecute or don't for single justice procedure crimes. And I think then the only way of kind of reducing the number radically is, as pointed out, to decriminalise some of the offences which are under there. And again, transform justice would be wholly in support of that. I mean, the ones mentioned, totally agree with. The idea that a parent who is usually quite vulnerable should be prosecuted and fined quite a lot of money for their child not attending school regularly seems just extraordinary. It's not rehabilitative, it's purely punitive. And again, there's no evidence whatsoever that approach actually makes the parent who may have a child who is deeply challenging, makes that parent more likely to send them to school. The kind of parents who take their child out for holidays, they're usually asked to pay a fixed penalty fine, and they do it because it's just a bit of money. So I give you a bet, we haven't got the data, that the ones who are prosecuted, and it is usually through the single justice procedure, are the more vulnerable parents who've got kind of stuck in the system and really, really having difficulties getting their child to go to school. So that's definitely one. One you haven't mentioned is the TV license. And I used to work for the BBC. I love it absolutely dearly, but I'm afraid the way they deal with the people not having a TV license is not fit for purpose. I myself, have had threatening letters. I mean, the language is extraordinary, and I've always paid my TV license, but they have a sort of very kind of scary way of approaching people. And then they do prosecute for non-payment. And with that one, there's no escalation. So in lots of other single justice procedure offences, there's a sort of, you offered a fixed penalty to pay, and if that doesn't happen, it escalates. Whereas TV licence, that's not the case. And the prosecutions are of many clearly vulnerable people. Tristan Kirk, the very good journalist, does tweets and messages about people, defendants he's seen in their form, talking about their circumstances. And these are defendants who, because they've actually filled in the form, that means it's 99% likely they're going to be convicted. And they've pleaded guilty anyway. So a mother, for instance, who was convicted of not paying her TV license. I'm a single mother of 3 children under 5. I also suffer with very bad mental health. When I was meant to pay for my license, I didn't have the funds to pay it due to being in a domestic violence relationship. and had no control over my finances. But I am now no longer in that relationship, and I would like to pay the TV license monthly. You know, she will have been fined probably a lot of money. Tristan's thing wasn't attached to what the fine was. And clearly, it's not a very appropriate measure for somebody in those circumstances. TV license could be like the other suggestions. Non-payment could be done through civil means and pursued through civil means. And I have no problem with that if we continue with the license fee, but it seems disproportionate to prosecute for basically not paying a bill when other bills aren't in the same frame. So I think on both fronts, out of court and you know, actually decriminalising some of these things, that would be a great idea, and I'll stop there.
Thank you very much, Penny. That's really, really helpful. I'm sure we'll come back to some of those issues as we move forward. Right, okay, I'm going to hand over to Christian, the final member of our panel, for his thoughts.
Thank you very much, Kevin. Yeah, I'd just like to reiterate everyone's comments. First, two very valuable reports. A lot of good work has obviously gone into these, looking at fines and some of the recommendations. So when Lucy asked me how I'd like to be described kind of for this event, I said, I guess I'm a justice campaigner, but alternatives are aggrieved traveller or stubborn commuter, really. So I'm very much just a member of the public. My involvement in the criminal justice system really began in 2023 about an incident that occurred in 2022. So, you know, here I am 3 years later, kind of still talking about it. Obviously had a big impact on me getting embroiled in the criminal justice system. And I was prosecuted by Northern Trains, really, about a dispute over a broken ticket machine that led to a penalty fare that was still disputed, that I thought was then a civil dispute, and I ended up getting dragged into court over this. So really, I'm going to focus on the kind of recommendation for taking fare evasion cases out of the criminal justice system. I really welcome that recommendation. This has been in the news a lot, that there is actually a case going on at the moment. I believe the next hearing is in December, about a Mr. Broheri. He's been described by the papers as kind of Britain's most prolific fare evader, but they've realised an issue while dealing with his case, that for years and years and years now, all of these prosecutions have been done by lay prosecutors, and they've kind of realised, hold on a minute, this might actually be illegal. This is even going back to the pre-2016 SJP cases. You know, there's no legal qualifications required you do have to be legally qualified to conduct litigation, and train companies for years and years and years have been using lay prosecutors. So there was an article by Gareth Caulfield, along with Tristan Kirk, who Penelope mentioned. He's one of the journalists that has really got to grips with these fare evasion cases. And he quoted a senior rail insider, because there is actually pretty much a pause on certain types of rail prosecutions at the moment while they sort out this mess, while they get additional kind of qualified legal resources to actually oversee them, rather than letting lay prosecutors conduct them. And the quote was, "It hasn't lost us money. We haven't opened the floodgates for claims either. We're now treating passengers fairly and sensibly without loss of revenue." And I think that kind of says it all. You know, they weren't treating passengers fairly before. I think that comes across by the actual report itself. I'll quote from: "The criminalisation of fare evasion means the state and the public bear the cost of enforcing payment that is owed to privatised companies. This is an outlier. No other company is permitted to use the criminal justice system to recover outstanding debt in this way." And I think that was my real issue with my involvement with Northern Trains. As far as I was concerned, this was a dispute about a broken ticket machine. I'd engaged. They knew exactly who I was. I was objecting to paying what was a £20 fine. You know, it wasn't about the monetary value. It's gone up since then, but it was £20 at the time. I I just wanted someone to actually listen to the argument. This ticket machine was broken. I want to have this argument heard, and I'm not prepared to kind of pay you off, even as the prosecution papers landed through my letterbox. So at this point, they've been simultaneously posted to the court. So this isn't a kind of threatened prosecution at this point, because of the single justice procedure notice is an actual prosecution. It was accompanied by a demand or an offer to settle for £135. And I think that really betrays kind of what was going on here. It wasn't about justice. It really just is about getting what they think they're owed, using the criminal courts as kind of a debt collection system. So kind of having said all that, I don't want to dwell too much on the specifics of these quashed cases and everything. I definitely support removing these fair evasion cases from the criminal justice system. It doesn't feel to me that debts are what the criminal justice system is before, and really that would remove a huge swathe of these kind of low-level fines. I think the figure in the report is 35,000 in intentional evasion cases. If you actually add up all train prosecutions, there's actually over 107,000 in 2023 alone. It's a massive percentage, about 40% of non-motoring summary-only offences. So that includes the kind of intentional fair evasion, but it also includes the really controversial ones, which are the bylaw 18 prosecutions. They're the strict liability ones. You have the wrong ticket, you get on a train, you suddenly committed a criminal offence. So I think the work on fines, to really consider people's personal circumstances when you're issuing punishments or issuing fines, I think that's really important. But from my perspective, when the criminal courts are kind of clogged up with this massive bulk of really debt collection cases, I think by removing those, you will hopefully free up so much time to really look at people's personal circumstances in more detail. I think the other obvious candidate for this, as Penelope said, is the TV licence evasion. It's an absolute anachronism these days. You know, if someone said, well, there's this new tech out, and if you buy it and use it in a certain way, you're going to commit a criminal offence, and we're going to enforce this by having someone come round to your house and kind of look through your windows to see if you're using a device in a certain way. Everyone would just say you're bonkers. That's such a bonkers system. I don't know whether we move it to general taxation, or, you know, obviously it's a bit of a political football subscription, general taxation, having to pay the license. But I think something needs to be done about that, and move those essentially unpaid debts into the civil system. So thank you.
Brilliant. Thanks, Christian. That was again really helpful, and I think one of your points is going to come up in the Q&A, and I'm grateful to everybody for the Q&A they've been putting in. If they could if you want to continue to do that, please do so. But we're going to start with some putting some of these questions out. I'm going to start with you, Lucy, if that's all right. I've got a couple of questions for you. One on Christian's points, really. I mean, and the report itself. Moving rail fare evasion into the civil justice system, the questioner says, would still involve trying to get money from people who are experiencing poverty and debt. How would you make sure the same issues are not repeated? And I'm just going to give you two questions rather than just keep on bunging them out. A further question, which is a new one on me, actually. I haven't thought about this. Has anybody looked at this is from Michael Oxley. Has anybody looked at youth court fines? Parents are responsible for payment, and if a child is a looked after child, the fine becomes the responsibility of the local authority. Which of course probably ensures it's paid, but doesn't exactly make much difference to the world. It's just circular money, really.
Yeah, so I can answer your first question first about moving rail fare evasion into the civil justice system. So we're absolutely aware that there are also issues in the civil justice system. This isn't saying that this is a silver bullet that will resolve all of these problems. We're really just making the principled argument that it shouldn't be a matter for the criminal courts. It's not right that the state's enforcing private money owed to private companies. It's not right, it's not proportionate that people are getting criminal records out of it. And I know that there's a lot of really great work going on to try and resolve some of the issues around the civil justice system, engaging with people in debt. A big shout out to Meg Van Ruin, who's been really supportive as part of this report. So yeah, we would just recommend that we'd hope that that work continues, that the system has those safeguards in the civil system as well, and engages well with people in financial difficulty to not replicate problems. And the second question, sorry, Kevin, was it about youth court fines?
Youth court fines, that's right.
Yeah. So our research only focused on the adult system. I know from conversations with colleagues in the office who have worked more on youth courts that there's definite issues with fines as well. We weren't able to get into it, and we had to focus. But if there are any funders on this call that would like to give us some money as a follow-up project, that's something we'd really like to look into, definitely.
Okay, thanks. Thanks, Lucy. That's really helpful. I'll come back to you in a minute, I think. But a couple for Carmen, both from Sheila Chingono. I hope I've got that right, Sheila. The first one is that she said she's a JP and she finds that there's often no way of verifying people's incomes. She understands the rules around GDPR, but surely a more joined up working with HMRC and DWP would assist. And one more comment before I ask you to respond. When I find it, just wait a second. Oh yes. We mentioned conditional discharge as an alternative. However, there's a lack of a punitive element in that. Don't you think, Sheila says that there's a risk persistent offenders will abuse the system knowing they're unlikely to really be punished?
Thanks, Kevin. So yeah, I'll take the first question first. I think what was really interesting is when we had our service user focus groups, a lot of them sort of assumed that the court had access to that information anyway, and were quite kind of alarmed and said it seemed really outmoded, seemed like kind of funny to them that they didn't have that information to hand. And I know kind of conversations are already in train about linking up and getting those data connections secured. So yeah, hopefully it could happen that way. But yeah, so it's seen a bit like the MC100 was seen a bit like kind of a pencil pushing exercise, or almost like a power play. They sort of thought, you've already got this information to hand, why are you bugging me? Why am I having to do this? So yeah, I think those data connections could really help. And also, as I teased out a little bit in the presentation and more in the report, the idea of having that real-time verification kind of reduce that burden on people to kind of have to provide that information themselves. And also kind of people would be less, especially high earners would be less able to rely on that kind of default income, and yeah, would be able to leverage more from those higher earners and increase the revenue. And maybe that would help respond to people who are struggling to pay in a more nuanced way. But yeah, I think it's something that is potentially in train and yeah, should be resolved. On the conditional discharge question, I think that's a really interesting one. I think we saw in observations that conditional discharge was definitely used ad hoc as an alternative to fines when affordability was in question. And there's an interesting quote in the report that talks about it being a magistrate's way of kind of making sense of a messy situation, fixing the conditional discharge. And I will say I don't think that a conditional discharge is toothless. You will be charged with both offences if you commit another one, so there's that hanging over you. And the idea of kind of combining a conditional discharge with signposting or a referral to an advice or support service, I think gives that more rehabilitative potential than a fine might have. And again, we saw that if a person is unable to pay a fine, it's just going to end up being remitted in enforcement court a few years down the line, so it just ends up kind of clogging it. But I do appreciate that we did get not a lot, but some practitioners feeling a bit wary and saying that maybe it's kind of going down and being more lenient than a fine. But I would suggest that yeah, maybe the fine will just end up going unpaid, like we've seen so many before, and adding another case to enforcement court. So yeah.
Okay, thanks, Carmen. That's really helpful. I'm a great fan of the idea of linking the court systems with DWP and HMRC as well. Not least because there's some higher earners that are getting away with not paying enough on their fines as well by not putting in their means. I'm going to hand a question to Jane now, if that's all right, Jane. The question is, what role can local magistrates play in advocating for the changes set out in these reports, given that they regularly see and are asked to dispense the unfairness of the system? Are there practical steps they can take locally to work with HMCTS to adopt these changes?
It's a good question and a slightly tricky one because as judicial office holders, we're slightly constrained in what we can advocate for, but that's partly why the Magistrates Association exists, in that it can advocate for such things. And there are local branches of the MA and also the National Magistrates Association, which has in the past commented on fines publicly and said they're a mess. It's done a substantial report on out-of-court disposals and talked about the lack of alternatives to fines. So I think my short answer is talk to the Magistrates Association, join the Magistrates Association.
And I'd just add on that that if magistrates are seeing the MC 100 not being used as effectively as it could be, even under the current system locally, that's entirely something that should be raised with the local HMCTS team as something that could be addressed, because the research certainly indicates that slightly to my distress, there was quite a big degree of patchiness of the of use of the MC 100, and that could improve. Recognising that could even get better as well. I'm going to ask a question of both Penny and Christian, but for good order, I'll ask Penny first, and then maybe Christian could come in after that, which is really about the SJP. I mean, this research has shown that it's still not as good as it could be, I think would be a polite way of putting it. Do you think both think that there's an appetite for government to actually change things here, or are we going to continue in the place we are? Penny?
I think there's a real appetite for government to change, and they did a consultation on private prosecutors, and all except the police of the SJP prosecutors, they count as private prosecutors. We're just waiting to see what their response, for them to publish about that consultation. My only fear about that consultation is I fear that most of the people who responded will have been the private prosecutors, and turkeys don't vote for Christmas. So we will see. But my understanding is Tristan Kirk is a hero, this journalist who publicised the unfairness of the system. And that has really rattled some in government, such that they are looking at it seriously, yes.
Okay, thanks. Christian?
I think there's a limited appetite to reform it. I don't think it's going to be abolished. As Penelope says, there's the Ministry of Justice report on private prosecutors and the single justice procedure. I think that was kind of commissioned to the two things, really, the Post Office, most importantly, which the whole country's kind of been scandalised by, but also the rail fare evasion cases. To have to quash 60,000 cases like that, it's a huge issue. Something has gone badly wrong. I don't think they'll abolish it completely. To me, one of the main issues is really the transparency of it. Tristan Kirk's done some sterling work to kind of get the actual charge sheets and the mitigation for a lot of these offences, and when he publicises it, everyone involved kind of holds their hands up and says, this is awful. How did this particular case get to court? They're sometimes withdrawn, etc. But there's a huge number of these that kind of no one has any visibility in. I know, speaking to both Gareth Caulfield and Tristan, who regularly try and get details of these cases is very, very difficult. There's no kind of case listing, you know, as to when something is going to be heard. There's a kind of central feed of cases that are in the system and will be heard at some point, but there's very little detail of those. So for a reporter or a campaigner trying to get to the bottom of, you know, how many of these are being issued, what sort of mitigation are we seeing, you know, who is actually issuing these, there's a real lack of information. So I'm waiting for the Ministry of Justice report kind of keenly. I hope they're going to recommend some significant reforms. The one thing that I think is absolutely essential before anything else is some regulation of private prosecutors. At the moment, there's no requirement to read mitigation, which I find absolutely extraordinary. And the BBC were actually defending this a few months ago, saying it's not our prosecutor's responsibility to read mitigation, it's the magistrate's responsibility. Maybe that's legally true, but it doesn't sound morally correct when you see some of the heartbreaking mitigation that Tristan publicises.
Thanks, Christian. That's really helpful. I've got a question about the research itself, which I think will be for Carmen. But Lucy, you start shouting if I've got that wrong. We're asked if the research identified any disproportionate effect with paying fines from those with ethnic minority backgrounds who perhaps English is not their first language, and their ability to understand the process is less basically.
Not in this phase. I know in the first phase we did some analysis of citizen advice data, and that came out a little bit. Lucy, is that right?
Yeah, so basically we looked at all of the public available data that we have on fines in the first section, and we have a really big gap on ethnicity. There's no ethnicity data on summary offences, which is where most of the fines are given out. So that was one of our recommendations from our last report, is that we need better data collection to be understanding these issues. But the centre has previously been part of some research on the experience of people in magistrates' courts generally with English as a second language, and found quite concerning findings around lack of access to translators or a lack of professionalisation of translators. So I'll share that report in the chat, because I'm sure fines would have been a sentence for much of these people.
In this report, sorry, Kevin, in this report, we do pick out a couple of cases that we saw during observations where the defendant clearly didn't have English as a first language, was kind of struggling to understand, but was just kind of pushed along, asked if you could afford to pay X. And obviously it's very difficult to say anything other than no in that stressful situation. So yeah, definitely an issue, and one that we need to learn more about.
Okay, thanks. And Lucy, a couple more for you, if that's all right. First one is, are the poverty-related offences enforced in large numbers? And the second one, I think this is for you, but Jane might want to come in afterwards. Ancillary orders seem to add to the total financial cost due. What guidance is given to magistrates about whether to impose prosecution costs and compensation or not? And should the victim's surcharge be discretionary as well?
I can start with the poverty-related offences.
Yeah.
So they're not enforced in large numbers at all. We found in very small numbers. Well, actually, it's important, I think, to step out truancy. Truancy is being enforced in large numbers. It's been a growing issue, as Penelope talked about. The numbers are quite high. But for the others, the sort of homelessness-related offences it's enforced around the Vagrancy Act. So begging and rough sleeping. And so the numbers are about 300 in a year. That's not very many, but this is still 300 people that are ending up in criminal court with a financial penalty for the activity that's directly from their homelessness. And for sex work offences, I have to say, we did some analysis on the remaining offences, and they're nearly defunct. These are not offences that are being used. It was going down to as small as 10 a year. For some, and in part that's because of the changing nature of sex work. It's moving online, and most of these offences focus on behaviour that's happening in public. For us, it was just really a moral argument that, if anything, this declining use shows that this is behaviour that doesn't need to be criminalised. And we're worried that if it remains on the statute books, if policing priorities change or a government changes, that it could rise again. So it's about updating the statute books to reflect sort of 21st century, really.
Okay, thanks. Jane, anything you'd like to
Well, just about prosecution costs and the surcharge. I mean, we have to impose the surcharge, and I think lots of magistrates were shocked when it went up to 40% from 10. I think the suggestion that it should be on a sliding scale or have some discretion around it would be helpful. I mean, the only segment we've got complete discretion on prosecution costs. The only leeway we have got is if the offence warrants compensation being awarded to the victim, and means is an issue, then we're expected to prioritise compensation, which means that the fine and the surcharge and the cost go away. And I think actually that's used quite often in court with people who don't have very much money. It's my experience, but experience varies.
Thank you. One for you, Carmen. How would vulnerable people or those without access to technology be supported to engage with the new financial assessment process? You're on mute, Carmen.
Sorry, one of our recommendations is that HNCTS should partner with community advice or other third sector local third sector services to be able to support defendants to complete the new form within the court building, and also to help them access the online system if for any reason they don't have access to that themselves, or they just are not or not comfortable doing that. So hopefully that would be one safeguard, and we're hoping that the online system would have kind of assistive chatbots to answer frequently asked questions. But yeah, it's a tricky one, and we're hoping during the research, lots of not lots, there was certain service users, a few service users who really missed having that fines officer located in the court as being something that they could just go and ask about. So kind of that partnering with a third sector organisation would hopefully bring a little bit of that support back into the court building for people to have in-person support.
Yes, I mean, I support all that really. I mean, it's tricky really, because sometimes the absence of technology for a small group of people is sometimes used as a reason not to make it available for 95 or more % of the population. But there has to be provision for people who haven't got access to those systems. But it's also important to remember that the AMC 100 is basically a mess, anything I think would be better than that. Okay, Lucy, Penny mentioned TV licenses, and I will join her in my love for the BBC, current issues notwithstanding. But non-payment is an offence that has received a lot of attention for criminalising vulnerable people and those in poverty. So would you recommend decriminalising that too?
Yeah, we definitely do. We've included it in the report as a note rather than dedicating it fully in that section. Mainly because we didn't have an alternative, and therefore we decriminalise and do X. It gets into a space slightly outside the scope of the research around funding the BBC and things like that. But we know that a lot of campaigners are calling for it to be decriminalised. We do support that. We're aware that it replicates very similar issues around disproportionately impacting people in poverty, vulnerability, particularly women, we know are disproportionately prosecuted for this offence. And we know that the BBC is being reviewed. Its contract's being reviewed, I think, in 2 years. So we are hopeful that decriminalisation comes onto the table again.
Thank you, Lucy. And Carmen, Jane mentioned the pilots in England and Wales in the 2000s to turn fines into unpaid work orders for those who couldn't pay. What do you and the people who are interviewed think about that as a response to people who can't pay anything?
Yeah, so that was something that was discussed a lot, and I think that there's a very small number of practitioners who did support it, kind of framed it as the least bad option when compared to an unaffordable fine, rather than being a good or even the best solution. I think most people, services and practitioners alike, kind of saw it as, disagreed with it on principle, kind of saw it as punishing people who can't afford to pay their fine, and kind of going up in the scale. So having a more onerous punishment on account of being poorer. But aside from that kind of disagreeing with it on principle. There was also we had a practitioners kind of solution focused workshop, and a couple of the magistrates highlighted some practical barriers as well to unpaid work orders. So they were worried that there was just like limited capacity to deliver them. There was a magistrate who worked in a rural area, and she's just said it was impossible to find an unpaid work placement there, and even if there was, people would have really a hard time getting there with limited public transport. And others said that just due to probation staff shortages kind of everywhere, it just wasn't workable. The idea of bringing like a whole new work stream to an already struggling probation service was kind of a non-starter. So I think, yeah, it was discussed, but then dismissed on that basis.
Thanks. Penny, I've got a question from Sandra Beaton, who knows more about this subject than I do, I think. So I'll just read it out. Transform Justice's survey on child remand indicated that police can send defendants to jail instead of impose a fine or another sanction. Assuming this also refers to adults, what's the legal basis for this?
I mean, the criteria of remand, I'm sorry if our survey says that, because it's doesn't include anything about fines. I think it's about risk of reoffending and so on. So if it gave the wrong impression, I'm sorry. But yeah, remand is risk of reoffending. It's kind of welfare and interfering with witnesses. It's those kind of things.
Okay. Thanks, Penny. That's helpful. Jane, just thinking about magistrates and this report. I mean, it's quite. It's quite an ask of magistrates to implement the new financial assessment process outlined in the report. I mean, training magistrates in financial advice and so on. What's your perspective on that? How do you feel about it?
I think you're right. It is quite an ask and fairly impractical in a busy court. But if there were other agencies to help the person produce the information, advisors in court, third parties. The comment about there's no longer fines officers in courts. There's nobody in courts these days to help people. It's all you have to ring up somewhere, and you're lucky if there's a sort of counter that you can ask where you're meant to go. It is an ask for magistrates to do it, but one would envisage that the sorts of groups who are prepared to help people with their technology, and I think the report talks about debt advice organisations, if there's a way of them helping defendants get that information together, or there's very quick and dirty ways of just checking on an HMRC or DW database. This person says they're on benefits. DWP are they? And get an answer says yes. Well, that answers that, because if you're on benefits, it's £120. This person says they're earning. What does HMRC know about them? That's probably a bit more complicated actually on HMRC. You need more data, but the benefits one is easy. I haven't thought it through, but I think like most of the solutions, it's not a straightforward. Fines are not a straightforward problem, so the answers are not going to be straightforward. But I'm sure some clever people can build on these reports and work something out.
Yeah, I mean, I think that's really helpful. I mean, I think so much of this points to the need for more joined up solutions. HMCTS can access DWP records, but it does it on the sort of fine enforcement end rather than the pre-fine end, and that's about the limitations of the technology that's available to them at the moment. It's all a bit of an overnight thing rather than an immediate thing. So there's opportunities there. I mean, and on the joining up front, I mean, it struck me that actually the sort of resources available to people with a civil debt in terms of advice and support are actually, I mean, I wouldn't say they were perfect, but I would say they're probably a bit more, there are a bit more of them than available than those sitting there with a criminal fine when it comes down to it. So so you know, there is some scope for each side of the equation to learn from each other, I think, on a bit of this. And of course, the report's recommendations about turning some of this into civil debt would help in that area to do. I mean, Carmen, have you got any thoughts on my point about the fact that joining up all this data means that people on high incomes are not going to get away with paying a sort of standard fine when it comes down
Yeah, I
to
think
it?
that features quite heavily in the report, and I think
Yeah.
I guess services were kind of unaware of it. They don't really know that that's something that maybe is happening, but magistrates in particular, I think, were really frustrated. They knew that this person was likely to be earning more than the 440, but they had to rely on that in the absence of other information. And yeah, I think it was definitely a frustration. Especially because people, yeah, there are people who were in who were in kind of dire straits that were kind of scrapping money together each month to pay off their fine. And there was also this idea that it gives people, especially at the enforcement end, kind of less confidence in the financial collection system. So they might be kind of a bit harsher with their enforcement. They might kind of be less likely to believe people when they say, actually, I've had a change of financial circumstances. So there's something about having greater confidence in the system of financial collection, I think, will have benefits kind of all the way through the system.
Yeah, and I suppose something I took from both these reports and the research really was a slight frustration about the degree to which there's regional variation around the system as well. In that, you know, if you could take the best of what's going on now and apply that across the country, you'd definitely get an improvement, even though there's still more to do as well. So there's some opportunities there as well. We're nearing the end, so I just want to give Jane, Penny, and Christian an opportunity to add anything else from their perspective in terms of what we've seen and talked about already. Is there any final points that you'd like to make?
Yeah, I mean, I'd just like to point out that on the single justice procedure, most people who are fined didn't even fill in the form. They might not even know they've been prosecuted. So, you know, we are likely to have incredibly vulnerable people who are fined at the average, but are much poorer, because there is a massive barrier to people responding to single justice procedure prosecutions. And the other thing I want to point out is there's a massive anomaly between what's charged for prosecution costs by different single justice procedure prosecutors. And I have to say, I kind of think HMCTS and magistrates have not looked at that very hard. They just seem to accept that TFL charges X and TV, you know, and DVLA charges Y, when in fact it's the same process and individuals shouldn't in the end pay more because, as we've discussed, the costs associated with fines can be enormous, can be very high.
Thank you, Penny. Jane, any final thoughts?
I think Penny's observation about the differences in what prosecutors charge is a very relevant one. They do. And just another inherent unfairness in the system about people with lots of money and people with not lots of money. For minor offences, the fine may well be by legislation capped at, say, level 3, which is £1,000, which means that that a defendant with an income of £100,000 can't pay more than £1,000, and if they plead guilty, they'll pay 666, which is nothing for them. But somebody on benefits, the lowest rate, will pay the full amount according to their relevant weekly income. So there's a problem with low-level offences and low-level fines anyway, which is that there is an inherent unfairness in them about income.
Thank you, Jane. And finally, Christian, and if you could include any words of wisdom for anybody else who ends up in your situation, that would be welcome as well.
Well, don't take legal advice of the person prosecuting you, I guess, would be the first advice, because in my case, they got it spectacularly wrong. Yeah, just want to back up really what Penelope said again. I think that the second strand I think about all of this, as well as kind of regulating the prosecutors, is really this question of why don't people respond? You know, we know there's thousands and thousands of cases where just by filling out the MC100 form, they are going to get a lower fine. Why don't people do that? I think there's a real engagement problem, clearly. Possibly if we move a lot of cases out of this system, we could look at it making more an expectation that if you are charged with a criminal offence, you should be there in court to kind of answer for yourself. Seems reasonable to me.
Thank you. Very wise words at the end there. So we're coming to the end now, and it's really just for me now to thank Lucy and Carmen, and Penny, Jane and Christian as well for their contributions today. Have really helped light up an important matter. And as I said at the beginning, it's a bit of a you know, given that it's coming up to Christmas, this is a bit of a Cinderella, and we really ought to get Cinderella to the ball if we can, and end up with a far better system for fines and fine enforcement moving forward. And I'm sure these reports will help with that, and everybody's participation today will help with that. So thanks to everybody who's joined us today. It's been really helpful to have you along and have your questions, and please go away and talk about it. And if you run into a minister, tell them about it, although I know the centre is doing a good job on that side as well. Everybody who's attended this event will be sent copies of the 2 reports, as well as the webinar recording as well. So you'll be getting those along very soon as well. So thanks to everybody, and enjoy the rest of your afternoon. Thank you.
Thank you. Bye.
Bye.